Thank you. So first of all, the beautiful library behind me signifies that the views that I will share are not the official views of the government of Israel, although a lot of the insights come from my work as a practitioner in the area of compliance and governance of technology, to which AI alludes. I'll try to share my slides and hope this works. Okay, so here it is, and I'll start right away as time is short. I will talk about regulation and governance in this field. And when we talk about regulation and governance, I'll try, first of all, to describe this separation that I'm aiming for between fundamental rights, which are the core things that we want to protect, and the more mechanical, what I call in the abstract second order, legal and economic tools, which are known as regulation and governance. And these are the way that we transcend values into the market and into our relationships as citizens and consumers, etc. So that will be the first part. The second part will be thinking about the regulation and governance challenges, successes and maybe some less successes in two areas that we have been trying to tame technology. One called data protection, protecting the right to privacy in databases and in technology, and the other cybersecurity, trying to mitigate risks. So what have we learned from there? And finally, the reflections, I put them here because I want to make sure that I say them, even though time is very, very short. So the three main insights are the importance of context in regulation and governance, no one size fits all for artificial intelligence, the need for multi-layered regulatory interfaces, and the need to build institutional capacity. So here I go. And as a point of reference, I'll use the OECD recommendation on artificial intelligence so that we have a baseline to talk about artificial intelligence policy. And I've divided these elements of the policy to two parts. One is the principles, which are basically more legalistic. They are aimed at affecting behavior, if you like, and we will talk about them for a bit. And the others are the other elements of government mechanics and how government can affect this move to the utilization of artificial intelligence. So these are all policy measures. These are more legalistic measures aimed at the market and at private sectors. So when we think about what the noble goal that we want to reach is, the citizen, consumer, worker, the human in the middle, the human in the center, and this is indeed also taken from the OECD AI Observatory, which has a lot of useful information about policy in the world. So we imagine all of these wonderful principles that we want to enhance human control, human transparency, human rights, and this is the noble goal that we aim to. But this is also the challenge for regulation and governance, because the way this happens on the ground is that these noble principles are the law on the books, and on the ground what we see are market transactions in which people transact with organizations, the organizations transact with their ICT providers. Sometimes they're affected by the way platforms and technology providers have designed this ecosystem. So at the end of the day, in order for us to be affected by these wonderful rights and fundamental principles that we have agreed upon, we need them to be intermediated through two social institutions. These are either courts or regulators. And if they are not players in this game, then we leave this human here to negotiate by himself, or to control by himself, or to deal by himself, and make sure that his rights and fundamental rights are protected in these markets. So this is the challenge. This is the regulation and governance challenge. How we take these important principles and make them applicable on the ground. And when we look at this challenge in more detail, I would like to argue that we have two main challenges in making these fundamental rights effective on the ground. One is a substantive challenge. What does the law say in a concrete situation? So we see this, and this is the first lesson from the GDPR and data protection, many novel situations in which we can see that courts in the EU are not sure what the right normative answer is. They want to go to the ECJ, the highest court in the European Union, to get guidance. So you see lawyers, smart scholars, having this sort of, I would say, ambiguity about the normative situation. So how do we take this normative ambiguity back to the ground? And the second is a more mechanical issue, which is really important. Even though we have the right answer, we know what the law is, we know how behavior should be governed according to principles, how do we make sure that organizations actually perform according to what is the law? So these are two very important challenges in the regulation of governance of technology. And of course, if we do things wrong, and this happens, we may reach chilling effects because some behavior will not take place, or we may have unintended consequences. So this is a really important part of the whole scheme. We need to pay attention to it. Again, looking at what we have learned from the GDPR, what does the law say in concrete situations? Hopefully, we would have a normative clarity coming from the law, regulations, guidelines, court cases, etc. But this is the optimistic case, and then we need to move on to the second issue of how we transpose these normative conclusions to the ground. But in most situations, we are still facing legal uncertainty regarding these type of decisions. And the organization has to take these decisions by himself. And sometimes he gets it right. Some of the times he will err in the business interest, and that will be a breach of fundamental rights. And sometimes, maybe if he has more careful lawyers, he will err on the side of too much application of fundamental rights, and that will have chilling effects on technology. So this is a serious issue, and of course the core answer that we've seen historically in data protection law is to put this heavy lifting on the shoulders of a specific institution called the Data Protection Authority. They are supposed to, like Hercules perhaps, hold this normative balancing on their shoulders and make sure that clarity is there in the market. And this is a question, and as I allude in the conclusion, I think the data protection regulators need to interface with other type of regulators in order to solve this issue. And indeed, we are starting to see regulation and governance reflections upon these challenges. An important article by Professor Raab, who is a longtime scholar studying from social studies, the effectivity of these types of regimes. We are seeing that even the more advanced concepts of the GDPR, accountability, data protection impact assessment, privacy by design, do not always reach wanted conclusions. One article, very recent, talks about demystifying this regime. So we have a normative challenge. The other side, when we move on, how can we affect corporate compliance, given that we know what the answer is? And here, what we can see is that because of the GDPR, because of imposing these types of accountability requirements, organizations do more in the term of internalizing these values to their activity. But what we need to take into account in this area, and this is a lesson from cybersecurity, is the way we see the supply side of technology working. And what you see here is taken from the OECD work on security of software. And what we can see here is this major challenge which cybersecurity practitioners live daily, in which software has bugs, that is, it is unsafe or malfunctions, and it needs to be fixed when it reaches its end user or consumer. and we need to have some sort of a scheme in which software can be recalled, rebooted, fixed. Think about these challenges when we talk about the complexity of artificial intelligence. So these challenges with cybersecurity now policy is struggling with only multiply when we talk about the problems with artificial intelligence. And some of these very advanced concepts that the OECD again is advancing in this area are relevant also for artificial intelligence. We need to be aware of these issues. The good news is that as far as we will be better in understanding technical risks from software, we will be better in understanding the more substantive risks from software because we will have better insights into how this software is working, that it is functioning correctly, that it does not malfunction. And this is a good, I would say, type of methodology to support these types of compliance exercises in artificial intelligence. So finally, my conclusions about lessons from GDPR and cybersecurity for artificial intelligence policy. The importance of context. When we do these types of value balancing, it is not the same when we do it regarding the health sector, use of artificial intelligence in the transportation sector, in fintech, in credit bureaus. You need to inject the specific type of values that are relevant to the specific situation in which a human is affected. And the good news is that in many of these areas, we already have regulatory institutions that can help us understand how things are supposed to be according to their interpretation. The other thing is, moving on to the importance of multi-layered regulatory interfaces, we need to harness the institutional capacity and the institutional knowledge, not only of the sector-specific regulator that I've just mentioned, but also in agencies looking at market failures, which are a phenomenon that we are experiencing in the digital world. So we need to see how sector-specific regulation, artificial intelligence regulation, interfaces with competition regulation to see whether there are market failures that need fixing, not from the substantive point of view, but rather from the economic point of view, and consumer protection in order to enhance consumer choice and human choice through time-worn concepts of consumer protection. And finally, this of course needs to interface with data protection, hopefully not as a conflict of subject matter, but rather as enhancing the role of the artificial intelligence regulation. I should say there is an important connection between data protection regulation and artificial intelligence regulation. Whereas artificial intelligence aims to regulate the end decision, data protection regulates the life cycle using the information when we talk about information about people. And there are some overlaps which we need to work out, both in order for it to be coherent and in order to reduce regulatory burdens. And again, when artificial intelligence will aim at regulating, applying substantive values to situations, the experiences of data protection are super important because this is what data protection wants to do. And finally, the last point is the importance of digital literacy within regulatory agencies. It is in this area, I think, more than many other areas, that the gap, the knowledge gap and the expertise gap between the market players which we aim to regulate and the people working in the government which are tasked with transposing these values is the most apparent. And so without building the digital expertise and the digital capacities within the government, within the relevant agencies, and as I've said in the previous bullet, I think this should go for all the agencies that are relevant. They will be unable to carry out their role in a satisfactory manner. So we should prepare for that as well. Thank you for having me here, and this is my last point. Thank you.
Thank you very much, Amit. This was really interesting and a very important topic that is kind of top of mind. And I kind of wanted to ask you, I actually read yesterday something about Facebook. Maybe you saw this, that because of some changes in the law, they are considering stopping some of the application like Facebook in Europe because of the inability to move data from Europe to the US. By the way, we at Ernix also facing these limitations. So we have data centers and clouds in different regions to adhere to the various regulations. My question here is an example that clearly Facebook is good. I mean, some of it is good. There is very good usage of it. On the other hand, this data privacy is really limiting. So how do we balance between those two?
Yeah, the question is, when we talk about good, is more complex these days, because we understand that Facebook has an important role in enabling us to communicate in new ways with regard to, our cell phones or whatever, communities, etc. On the other hand, I think that it's now less of a dispute that while facilitating all of these new types of communication and collaboration between people, there is an underlying privacy transaction which is not existent in other types of communication that we have in other places. And therefore, data protection aims to protect this type of data that we share, because when we talk on Facebook amongst ourselves, we are not sure, and obviously there are some great studies by Acquisti from Carnegie Mellon and his colleagues about what we really understand about what's going on under the hood. But in any case, the Cambridge Analytica event and the Brexit use of Facebook data showed that these types of, I would say, rather innocent communications that we have within our communities, COVID-19 discussions, are not so innocent when they are conducted on Facebook, because it's not a completely neutral platform. So, and I think that we see now the regulation in the world trying to balance between the value that a lot of people see in communicating in these platforms and the risks which are not theoretical at all these days.
Yeah. Now, it's very interesting, and I think probably it's a topic for another discussion about the change or the difference between privacy laws in the United States and in Europe. Very restrictive in Europe, less restrictive in the US. So actually, this leads to a kind of an interesting question that, do you expect a new C-level role, which will be called Chief AI Ethics Officer, in a similar manner to like the Chief Privacy Officer? What are your thoughts on that?
I think that the way, at least if we look at the way the European Commission has designed in a very complex and sophisticated way this draft regulation on artificial intelligence, it's based on all the things that are in the GDPR and then some really interesting and smart regulation and governance mechanisms. I think that it is almost necessary for organizations that are utilizing AI on a large scale, developing AI, to have someone dedicated to this, either in order to understand the compliance side, which will be difficult and complicated because it's a tricky issue, as I've tried to describe, or in order to, that's what we hope for, to use the data and to create better artificial intelligence, such that down the road, when the product reaches clients and clients of clients and clients of clients, it does not reach a legal or regulatory barrier. So hopefully, I guess from the government's point of view, this will be a business advantage, that AI is not only compliant, but also ethical and protective of fundamental rights.
Yeah. Okay, good. Another question that I have for you is, what are the prospects of global harmonization of laws and regulations on artificial intelligence?
So this is a very tricky question because it seems that there are a lot of documents coming from many jurisdictions talking about fundamental principles for artificial intelligence. And one of my motivations for this talk was to shed light on the fact that we can agree on the values. We probably will agree on the values, and some may say that the values already apply. We didn't even need to say them. The US Federal Trade Commission said in a blog post in April, if you use artificial intelligence in an unfair way, we will come after you, even though their law doesn't say artificial intelligence. It just says don't act unfairly. So I think that there are really important efforts by the OECD, by the Council of Europe, by other organizations to create some sort of harmonization. It will be critical for utilization of the benefits of AI because of the question that you've asked me before. If we cannot share knowledge, data sets between jurisdictions, we will have territorial AI. They will only be calibrated around a specific population. There are many issues around that, inclusion, etc. So it's a heavy-duty issue. And because things are moving very fast, hopefully this will help policymakers around the world come together and reach some sort of understanding around this.